Hi everyone, welcome. This is Attorney Verjgar Abedian, and today I'm going to talk to you about the 5 questions I get most from landlords in my California real estate law practice. The first question I get is, the tenant stopped paying rent, what can I do? So there's a few ways to handle this issue. The first way is to determine whether you want to keep the tenant inside your home or your property and have them keep up the tenancy. You can send them a letter to pay rent, and you could take them to court to get the rent paid, either a small claims court if it's under the jurisdiction of a small claims court, or you can take them to the superior court if it's higher than the small claims amount. Second thing you can do is you can go through the process of evicting them. And to do that, you have to provide them with a notice, a pre-litigation or a pre-eviction notice, which is most of the time a 3-day notice, depending on what your lease agreement says. Sometimes it's different, but you have to look at what the lease agreement says. So what the lease provides in the event of a default in the rent payment. So most of the time, if you have a lease agreement, it'll tell you what specific action you can take in the event of a default in the payment of rent. So that's the first thing, is to check to see what the lease says. And if the lease is silent on that, then you can proceed with an eviction if you want to remove the tenant from your property to get the possession of their property back. Those are your options: to sue the tenant in court for the rent and get a judgment against the tenant, or to file for an eviction and remove the tenant from your property, in which case you can also sue them for the balance of the lease payments that they didn't pay. Second question I get is about tenant not providing their insurance. So this is determined whether, this will be based on whether your lease agreement provides for the tenant to provide tenant insurance for your property. While they're a tenant there, they have to maintain insurance to take care of their personal property inside their space. Sometimes the tenants do not want to pay for an insurance policy, or they're just haven't gotten around to getting it yet. So what can you do? First thing to do is to provide them notice that it is a requirement under the lease, if your lease does in fact call for that, and give them an opportunity to obtain a policy and give you proof that they've taken out that policy. If your lease provides for it, then they can. You can also use that as a justification for a breach of lease agreement. If the lease doesn't in fact provide for failure to provide insurance, would put the tenant in default and breach the lease, in which case you can refer back to the default section of the lease to see what rights you have in the event of a lease default by the tenant, which can include eviction, which can include taking them to court for an injunction to force them to get a insurance policy, or it could also include the landlord taking out a policy on behalf of the tenant and then charging back that cost of that policy to the tenant in the form of rent. So it depends on what your lease agreement says. The third question I get often is, the tenant is making too much noise, what can I do? Noise is basically a nuisance. So what you can do is, again, look at what the lease says. If the lease provides for a nuisance, if the lease provides that nuisance or is a default in the lease, then you can use that to provide notice to the tenant that they're in default of the lease agreement and to stop making the noise or causing the nuisance, and that they have a certain amount of time to rectify or correct the situation. Otherwise, they would be in breach of the lease agreement, and you can use that as a cause to evict them. Other nuisances other than noise are smoking, or loud music, screaming all nights of the hour, playing loud music outside the hours of the property's rules. Most of the time, the quiet hours start after 10 p.m. depending on what your lease agreement says. Again, you have to look at what the house rules are or what the rules are in your lease agreements. But if they are doing things outside of those hours, that would put them in violation of that provision, causing a nuisance. They would be potentially, yeah. So it could be smoking, it could be drinking, it could be partying, it could be doing things that disturb other tenants, it could be fighting, it could be intimidating other tenants, or not letting tenants or people come on and off the property, basically causing issues with the property. The fourth question I get asked is about tenants doing illegal conduct. Illegal conduct can be selling drugs, doing prostitution, selling marijuana out of their unit, or doing things that are obviously illegal. And what can they do? So again, look at the lease agreement, see what it says regarding illegal conduct. What does the default provision in the lease agreement say? Most of the time, the lease will address this issue. If it's not addressed in the lease, state law provides that illegal conduct can be a justification for an eviction. So you can use the specific provision of the Civil Code or the Code of Civil Procedure to provide them with a notice of illegal conduct and use that to proceed with eviction proceedings. Or you can just write them a letter letting them know of the conduct, and that if it's not corrected, then you can proceed with the eviction proceedings. So that's important to do, because if you don't address it as a landlord, you could potentially get fined by the city. You could get fines against you from other tenants, or from you could get lawsuits against you from other tenants, or fines from city officials, and they could fine the property. They could fine you as the landlord, daily fees and fines depending on what the conduct is. So it's always important to address those issues right away as soon as they happen. The fifth question I get asked very commonly is, the tenant's not leaving after his lease has expired. What can I do? So this is considered a holdover tenancy. And again, you always have to look to see what the lease agreement says regarding this particular issue. Oftentimes, the lease will say that a tenant remaining in possession after the lease expires is considered a holdover tenancy, which will convert to a month-to-month basis. And the tenant can keep paying rent, and the landlord will accept it on a month-to-month basis. If the lease says that the landlord will not accept rent and will not accept the holdover, then they're in breach of their lease, and you can move forward with the eviction proceedings to kick them out of your property. You have to give them a notice, depending on how long they've been there. If the lease had a fixed termination date, a fixed date, and they left and they told you they will be leaving at the end of that period, or they just never left after the end of that period, you can file an eviction right away with the court to get them out. If you've let it drag on for a longer period of time and you've actually accepted rent from the tenant after the tenancy terminated, and it's gone to a month to month, then you have to the other rules kick in, and you have to provide them with a longer notice period to vacate the property. So those are the 5 most common questions I get. If you guys have any other questions, you can leave them in the comments below, or I look forward to talking with you in the next video. Thanks.